You covering for Mr. Herman?
I am, Your Honor.
Victoria Young here?
No. Oh, so you're just on.
They were supposed to provide me some paperwork. Do they have paperwork?
No, Your Honor, I do have. The only copy of the police report we have is still the redacted one. I do have a letter from the Lansing Police Department that says they denied our request for an unredacted because the court has sealed that file or that matter. And the officer, we did subpoena the officer. He was going to be here. He can't be here today. If we needed to have him appear, we could adjourn it. I also have 3 other witnesses down the hall. You have a copy of the report or anything?
I was just looking to see where the notice to quit was in this file. What a complaint to see. Summons. Just showing, you know. Oh, okay, wasn't Miss Young? Okay, well, the bidder failed to appear. She previously did make a statement indicating that the shooting didn't take place and that she was a witness. I believe is what her statement was. You just have a redacted copy, so you can't decipher which way or the other who it is. And who are your witnesses?
One is the maintenance guy that heard the shot and called the police and saw the group walking. And I believe they all went down towards her apartment after the shooting and recovered the gun from out of her apartment.
The maintenance man recovered the
No,
gun?
the police did.
Okay, so we need the officer.
We would need the officer if we're gonna.
You don't
do a
really
trial.
need the maintenance man. I just want to know. She said it wasn't her. She was a witness. It wasn't her unit. So we just need the officer. So I already said it for the officer. I'm not, and that's only because she appeared every time. And she was here on the 15th, she was here on the 28th, she was here on the 15th of March. I already said it, I'll let the officer appear. If she doesn't appear at the next one, then I'll accept the default. Yes, please.
I can add May 2:30.
Okay, well, we set it for May 10th at 2:30. I'll give you that back. Thank you.
Thank you, Judge. I have printed 3 of those if you
We'll
want to
keep
keep
it in
them.
file. Perfect. Sounds good. Thank you. Same to you. That was Victoria. Okay. Desiree Henry present. Meredith cannot appear. Okay, is the property vacant? Mr. Cyber?
Yes, Judge. Good morning. Afternoon.
You're the property manager?
Yeah.
Is this property vacant because her notice to appear was returned?
To my knowledge, it does not. She has officially turned in keys on notice.
Is her name on the mailbox?
To my knowledge, it's still.
This says return to sender not deliverable. This came from the court.
Okay.
And the only reason why I'm not inclined to grant a default at this time is because this was previously dismissed because Mr. Cyber failed to appear timely. And so she was notified that the case was dismissed, and it doesn't look like she received notice to appear today because it was returned non-deliverable. What address should it be?
1254 West Edgewood Boulevard, apartment number 6.
Yeah, that's what's on here. And the previous notices went to that same address. Those did not come back. This particular one did come back on April 10th. We tried to mail it out on the 29th. It looks like. Of March. And no one has a way to contact her.
The phone number is not good, which is on the file. The best thing I could probably do is give a 24-hour notice and have maintenance come in to check.
You said her number was in which file?
The one in my system.
Oh, your file, got it.
Yeah.
I'm gonna reset this so I can allow you to check to see if the property is vacant.
May 10th at 1:30.
Mr. Cyber, we're gonna reset this for May 10th. At what time?
Thank you,
At
Judge.
1:30.
Thank you.
Thank you. Okay, that's that one. We're on the record in the matter of Atwood Properties versus Michael Jones, file number 23-00022 LT. Council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff at Wood Properties.
And Michael Jones is present today. Mr. Jones does not have an attorney. That's correct, Mr. Jones? You're muted, sir.
Yeah, yes,
Okay, thank you. Today was a date and time set for a hearing. Mr. Whitty, my understanding is that you did come to a resolution.
That's correct, Your Honor. I'm happy to place it on the record.
You can do so at this time.
Thank you, Your Honor. The parties have agreed to enter a consent judgment in this case. Rent to retain possession is currently owed in the amount of $3,320. Court costs are $220.43 for a total of $35.40.43. We also asked for a money judgment in this case, which is why we didn't do a conditional dismissal in this instance. Damages are $3,217.33, consisting of rent prorated through today's date. Court costs are $220.43 for a total balance of $3,437.76. I explained to Mr. Jones that partial payment wouldn't prevent issuance of a writ, and that if he didn't pay that balance in full before May 8th, we would have the right to come back to court and ask the court for an order of eviction. We also discussed his rights under MCR 4.201I, and at that time, he gave me permission to sign the consent judgment on his behalf, which I'd also like to confirm on the record.
Mr. Jones, is that correct?
yes,
Okay, so it's your understanding that you're gonna enter into a consent judgment and you're going to pay the rent to retain the amount of $3,320 plus court costs $220.43 for a total of $3,540.43, and that you will pay that on or before May 8th or vacate the property before that date, sir?
He didn't say vacate the property before that date. I didn't understand that part, but yes.
Well, you can pay the amount before that date. You understood that part?
Yeah,
Okay, and that's what you're agreeing to do is a consent judgment. So you're agreeing for judgment to enter against you, correct?
yes,
Okay, so you understand that you had to give up certain rights in order to enter into a consent judgment, sir?
yes, he explained it to me. But
You have the right to be represented by counsel, sir, and you do not appear with counsel today, but you were advised of your right to be represented by counsel. Are you going to waive your right to be represented by counsel in order to enter into consent judgment?
yes,
Okay, and then you also have to give up your right to have a hearing or a trial in this matter. Did you want to waive your right to have that hearing today, sir?
yes,
Is anybody threatening you to get you to waive your rights today to enter into consent judgment?
no,
You understand that partial payment will not satisfy the judgment. You need to make payment in full of the amount of $3,540.43 by May 8th. Otherwise, they can request the writ and execute the judgment after that time. You understand that?
yes, ma'am.
Okay, do you have any questions today, sir, for the court?
Like I said, I know I'm gonna try, I just started another job and it was kind of difficult for me because I had people that was helping me out, but they ran out on me. So they left me with all the bills and everything is in my name. So I'm just trying to do my best to try to get everything caught up.
I recognize that, sir. What was the question?
Well, I'm just, they want me to be out by May 8th, even if I do pay them, I mean, whatever, I'm still gonna pay whatever I owe, but I still have to be out by May 8th or.
If you pay that amount of $3,540.43, you can retain the property. You can stay in there, but you gotta pay it before May 8th.
Okay,
Do you understand that?
yes,
Okay, do you have any other questions?
no, ma'am.
Okay, and you've given Mr. Woody permission to sign this judgment on your behalf, correct?
Correct.
Okay, you have 3 business days from to date. If you leave this courtroom and you determine that you misunderstood the rights that you just waived, you can return to the court and file a motion to set aside the judgment. You would just have to indicate how it was that you misunderstood your rights, okay?
Okay,
Do you have any questions at this time?
no, ma'am.
Any additional matters for the record, Mr. Woody?
Nothing for plaintiff, Your Honor.
Thank you, Mr. Jones, you're all set.
Thank you, Your Honor.
Victoria Young? She hasn't started her, yeah. Okay, we're on the record in the matter of Rao Realty LLC versus Wilfred Margonica and Camden Hamel. File number is 23-00375 SP. Council appearance.
Sorry,
Mashni,
Raymond
are you
Mashni.
not-
Yeah, I'm sorry, I thought I hit the mute button, unmuted. Raymond Mashni appearing on behalf of the plaintiffs. And I did speak with the defendants and I think we have a resolution.
Okay, sounds good. And then I see Kanja Sintish, correct?
Yes, ma'am.
Okay, today was the date and the time that was set for a hearing on a land contract forfeiture. Mr. Mashni, how have you all decided to resolve this?
We've agreed to request an adjournment in this matter for a few weeks. And I am going to send them each separately a deed in lieu of forfeiture. And they're going to sign the deed and return it to me. And then my client is going to send them each $500. And they're both, I think, already out of the property and don't wish to retain it. So once the deed is signed, then I'll dismiss this matter.
Sounds good. Is that what you want to do, Ms. Intish?
Yes, ma'am.
We'll get you a new date.
May 10th at 4:30.
May 10th at 3:30.
Okay, thank you.
No problem. Any additional matters today?
No, I don't.
Okay, you're all set. Thank you.
Thank you.
Excuse me, Honor, you said 3:30?
Yes, on May 10th.
Okay, thank you so much.
You're welcome. Mr. Barker is appearing for Herman, correct?
He was just for the 130.
Oh, okay. Victoria Young? You have a file?
Yes, I'm here.
Okay. Well, were you supposed to be here at 2:30? I mean, at 1:30?
Yeah, I lost track of what day it was. I got a lot going on.
Okay. The attorney for the plaintiff did appear and they did come with witnesses. You were not here. I granted you a courtesy only because you've appeared for every other court date. And so I reset it to May 10th at 2:30.
Okay.
You need to appear on time, ma'am, because they're subpoenaing an officer witness, okay?
Okay.
You're all set.
You said May 10th at what time?
It's at 2:30.
Okay, thank you.
You're welcome. So, is someone here on behalf of Edward Rose Associates?
Yes, Judge, I am. It's Joe Joseph.
Oh, okay, sounds good. Thank you.
Yep.
Okay, I see Octavius Murray here. Mr. Murray, do you have an attorney?
Sorry, no, I do not.
Okay, can I put you in the private meeting room with Mr. Joseph, the plaintiff's attorney, to see if you all can resolve this matter?
For sure.
Thank you, Judge.
You're welcome. Joe Joseph to room 1, Octavius. Joseph Vital. Robert Budrow, is Robert Budrow here? I see Michael, I'm sorry, I see Chrissy Peed. Chrissy, who's Michael Peed?
That's my father.
Okay, is he present today?
He's trying to log in, but he's having trouble logging into the Zoom.
Okay, is he in the same house with you?
I'm not sure if he's home yet. He's at work. He just messaged me and said he's trying to log on, and if not, he's gonna try to get home. He's just working around the corner right now.
Okay, and do you have an attorney representing you?
No.
Okay, Mr. Vital, you're representing yourself, correct, Mr. Vital?
Yes, Your Honor.
Okay, I'm gonna put you both in a private meeting room to see if you can come to an agreement. That could be in the form of a consent judgment or a conditional dismissal, whatever you all agree to. If not, we'll have a hearing, okay?
Thank you.
No problem. Anybody here on behalf of Foxland Holdings LLC?
Yes, Your Honor. Larry Dahlstrom with Nags Break here on behalf or substituting in for Daybreak and Rhonda Kunkel.
Okay, no one's appeared on behalf of Darlene Rollin.
My understanding, hopefully, the consent order for conditional dismissal agreement has been reached with the property manager, Mary Jo Schmidt. So hopefully she'll show that that's what we're prepared to enter today.
I know the last note was that she had made payment arrangements and had been making payments, so,
This is true.
okay, so the understanding was that there was gonna be a conditional dismissal.
Yes, Your Honor.
If I can reset this so that you can work that out. I don't know if your client has contact, but she's not appeared in court at this time.
Well, I thought it had been worked out and I had the terms and conditions to set on the record. So
Okay. There's a conditional dismissal. You don't have to actually put it on the record if she signs it and you file it with the court.
I'll talk to Mary Jo Schmidt. I'm subbing in. I don't know if that last part of the conversation occurred or not, but I will follow through on it, Your Honor.
Okay, Ms. Schmidt?
Yes.
Oh,
You entered into
hi.
a conditional dismissal with the tenant, that is?
Yeah, I mean, we did figure it all out, and she actually has paid quite a bit already, so she's well on her way.
Okay, so is it possible that you can get her to come in and sign that conditional dismissal?
We probably can figure out a way to either take it to her and have her sign it maybe or something, yeah.
Okay, I'll reset it. I'm not sure why she didn't appear today, but if
I'm
she's
not
well on
sure.
her way.
Yeah, she said she would be here, so I'm not sure.
That's it, the 3:15. May 10th at 3:15.
Thank you, Your Honor.
No problem. We're all set on that one for today. No, I can't join the breakout room. Let's bring them back. Are they in separate? Oh, they're in separate rooms, that's why. Were you in a room by yourself, ma'am?
Yes, Your Honor.
Okay, if you go back to room 3, he's in there now.
How do I do that?
You gotta look on your screen and it should say a breakout room or return to breakout room.
Breakout rooms?
Correct. Mr. Joseph, did you all come to a resolution at all?
We have a consent to put on the record, Judge.
On the record, in the matter of Edward Rose Associates versus Octavius Murray, file number 22-03957 LT, appearance for the record.
Thank you, Judge Joe Joseph.
Thank you.
Okay, and Octavius Murray is present via Zoom. Say was the date that was set for a hearing and the parties have entered into an agreement. Mr. Joseph, can you put the terms on the record?
Yes, and we've agreed to a consent judgment of possession. There is a balance of $770.84 that's due, plus court costs of $169.16, totaling $940, with a writ to issue after May 10th if it is not paid, and defendant is still residing in the property. Mr. Murray did indicate that he paid $200 today. I told him that would be get credited.
240, I'm sorry.
I've gone over Mr. Murray's rights under 4.201 regarding the 3-day rescission rule, and he has consented to having us sign his name to this judgment. And we are asking the court to allow it to enter as set forth.
Okay. Mr. Murray, that's your understanding of how you're going to proceed?
Yes.
Okay. So you understand you have the right to proceed to a hearing in this matter?
Yes, I do.
And you want to give up that right today?
Yes, that's fine.
And you have the right to have a representation by an attorney. You want to waive that right as well?
Yes, that's fine.
Anybody promising you anything to get you to waive these rights?
No.
Any threats being made to you to get you to waive these rights?
No, it's not.
You got 3 business days from today to return to the court. If you leave here and you determine you misunderstood any of the rights that you had to waive in order to enter into this consent judgment. Otherwise, the judgment will enter. You will pay the amount in total of $940 on or before May 10th, or vacate the property by that date. You understand that?
Mm-hmm. Yes, I do.
Is that okay? Thank you. Do you have any questions for the court?
No, I do not.
Have you given Mr. Joseph permission to sign the consent judgment with your name?
Yes, I have.
Okay, you're all set. Thank you.
Thank you,
Thank
Judge. To the court. Good luck, Mr. Murray.
Of course. Thank you.
Indeed. Are we ready, Mr. Vitale and Ms. Peed? Am I pronouncing that correct, or is it Peedy?
It's Petey, Your Honor.
Thank you. Are we ready, on your matter, Mr. Vitale?
Yes, yes, Your Honor, sorry.
No problem. We're on the record in the matter of Joseph Vitale versus Robert Budrow, Michael Peedy, and Chrissy Peedy, file number 22-04155 LT. The parties are present in the virtual courtroom via Zoom without counsel. You've met privately. And did you come to a resolution?
No, Your Honor.
Okay. Looks like Robert Budrow failed to appear at the last court date, and I granted a default judgment. Let's see, this is a hearing for non-payment of rent. There was no agreement. This is a real simple one. Either, how much money are you alleging she owe or they owe?
$10,770 in back rent, $450 in late fees, which I've assessed at $75 per month. And that would take them through today because the lease is actually due, the new payment would be due on the 27th. We also have court fees and service fees. And I apologize, I paid them all in one lump sum because I had 3 together. So I don't know if you have that, the number in the file. I think it was $130 for the court fee.
Okay, give me the rent to retain again.
10,770 is past due. Prorated through May 8th would be an additional $717.99.
$717.99.
Yep, 717.99.
Okay. And Ms. Petey, you're disputing that that's what's owed?
Yes, Your Honor.
Okay, what is the basis of your dispute?
Well, I mean, I owe the rent. I haven't paid him rent, but in January, Joseph came with the city of Lansing to do an inspection on the home. And I informed the city of Lansing worker that the basement was infested with fleas and there were mice. And the city of Lansing inspector refused to do the walkthrough because he did not want to bring anything back to his animals and left that day. And the same day, Joseph went and filed this eviction. This mouse, I've had pest control out here, is infested with mice. He said there are over 100 mice in this house. There are like mouse feces in my underwear drawer, all throughout my kitchen. The mice are crawling on my kids' bed at night and pooping on their beds. Like I'll clean and it'll just be reinfested with mouse feces within 3 days. And it's going to cost almost $8,000 to get rid of the mouse problem in this home. And pest control said it's a hazard. And I have been so sick for months with like bacterial infections over and over again. My kids have skin infections from the mice, and they've been on heavy steroids because of it.
Okay. Do you have any evidence to support your claim of the conditions of the property, ma'am?
I do. I had pest control come out and do a thorough investigation, and the city of Lansing is also supposed to be out here in 7 days to do an inspection further on the home. I have video, I have cameras set up in the house, video showing mice coming in and out of my stove, crawling on my counters at night. I've been literally having to keep all my food in boxes for over 6 months. I can't even keep food in my kitchen. All my food is being stored in boxes on my table.
Okay.
I have pictures of the mouse feces in my underwear drawer.
Okay, so you do have this evidence, you just have to get it to the court, is that what you're stating?
Yes, I have all the evidence. I have video evidence, the inspection done by Orkin Pest Control. I have photos of everything. They also took photos of everything and said there was not one room in this home that did not have mice.
Mr. Vitale, did you get a copy of any of this evidence?
No, in fact, the only conversation that was had was that she had fleas in the house and she thought it was because there were mice in the basement. And that was on that date that she did say.
Okay. So,
That's been,
and you said the city is supposed to be out there within 7 days, but they came previously?
well, that was an inspection, Your Honor, that Joseph had being done to make sure the house was up to code to be rented, I guess. I'm not sure. I called the city myself. And I called them a month ago and they finally just got back to me. I would have to exit out of here because it's in my notepad, but I have the gentleman's name that's going to be coming out here to do the inspection.
Okay, I'm gonna adjourn this matter. I need you to come in person and bring your evidence.
Okay,
Your Honor, I need access to the house to be able to obtain quotes if this is in fact happening.
I don't believe that Ms. Petey would have a concern with that, would she?
I have no concern with that, Your Honor.
And what number would I reach you because you've blocked my calls to your?
Give me just
That's
a moment.
incorrect, Your Honor. I actually tried to call him a couple weeks ago, as well as Sharon from Tri-County Office on Aging and Kathy from St. Vincent de Paul. They both have been trying to reach out to him to pay him at least the $4,000 that he filed for, and he won't return anyone's phone call. And I have also messages from Sharon at Tri-County Office on Aging stating that she's been trying to contact him and has left him multiple messages, and he will not return anyone's phone call.
Okay, well, he says he wants to know what number to contact.
My phone number is 517-202-8177. And he also has my mother's phone number, and he has not tried to reach out to my mother also, so. He has our phone numbers.
Okay, and so, Mr. Patel, are you saying that you were aware that there were fleas or allegation of fleas?
She told me that there were fleas when I was there, and I said that there were no fleas in the house prior to her moving in. She does have multiple animals, and they were not on flea or tick prevention. And I said, you know, if you walk the animals down the street in a downtown area, there's potential that they could have fleas. There were no fleas in that house. The city inspected that house just prior to them moving in and issued a rental certification.
Okay.
So I think at a certain point, you know, condition and, you know, animals have a bearing on some of these activities. And I just like, certainly I don't want to have a house that's infested, but I can only be tenant isn't also doing what they need to be doing.
Okay, sounds good. So what we'll do is we'll reset this matter or continue it, I should say, primarily because she's got some evidence that she wants used to support her claims. And that evidence should be provided to you, Mr. Patel, so that you can know what it is that you're disputing or being claimed against. Ms. Petey also is stating that the city is going to be out there within the next 7 days. And so maybe by then there'll be a report before we have our next hearing. So I'm going to set this out 2 weeks. We can do May 10th at 2. May 10th at 2 p.m. in person at the court. Or Ms. Petey, if you drop off your evidence beforehand, you can appear via Zoom.
Okay, I will drop off the evidence, Your Honor.
Okay, you will drop it off to the civil department, okay?
Yes, Your Honor.
Thank you. Mr. Patel, do you have any questions or issues that we should address today?
Is there any particular reason why only one of the 3 tenants are appearing at each court meeting here?
I could not tell you, but I've already given you a default on one, and you can default Mr. Petey as of today.
Okay.
My father actually just got home.
Okay, well, the hearing started at 2.
Yes. Okay.
He's not here.
Okay.
Yeah, that's not him who just joined. So we're doing all we can to provide access to the court. We even allow people to appear virtually from their comforts of their homes or in their cars if they pulled over safely or wherever they need to pull over. But it's a court date and there's a list of people that are waiting behind you. And so when people don't show up, you're disadvantaging them as well. And so he did not appear. He could have appeared and logged in from his work wherever he was, but he didn't do that. And so Mr. Vitale has the right to seek a default judgment for his failure to appear.
What does that mean, Your Honor?
That means that he by default loses because he didn't appear in court. And Mr. Vitale wins his case against him. So as of right now, the only person proceeding is you, ma'am, because you're the only one who's been appearing in the court.
She said because you didn't log in.
Because I don't know how.
He couldn't log in. He was trying and it would not let him log in for some reason.
Tried and tried and tried. I don't know.
Let me speak to him, please.
Okay.
Ma'am, I'm not good with electronics, so I couldn't figure out how to get into your system. I tried like 3 different times.
Okay,
I'm
you
not-
did know, sir, that you had court at 2?
Yes, ma'am, I was here in time.
He just couldn't log
Okay.
in.
I just couldn't log in.
Okay. Okay, so this is not the first or second hearing that we've had in this matter. And so what I've stated to your daughter, and I'm going to repeat that to you, is that
Yes,
the
ma'am.
court dates are set for at a certain time, and we're giving grace by allowing you all to appear virtually. You could have appeared from your job, you could have appeared from your car if you were not driving. You could have appeared from outside, long as you had logged in. It's your responsibility if you're going to access the virtual courtroom to learn how to log in before the time that you're supposed to be here, okay? Because if you're not
Yes, ma'am.
here and we wait 30 minutes, I have to grant the other party what they need in order to move forward with the case. Do you understand that?
Yes, ma'am.
I recognize that you had some technical difficulties today, so I will not, and you have appeared at this point. We haven't concluded the hearing. And so you need to appear at the next court date on time with Ms. Petey, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Okay, you're all set for today.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. Who's just joined from an iPhone?
Can you hear me?
Ma'am?
Miranda
Yes, what's your
Finley?
name? Okay, Miranda Finley. Okay, do you have an attorney?
I don't.
Mr. Sahlstrom, you're on that matter, correct? You're muted, sir.
Hello? No, not me.
I apologize, Your Honor.
You're on the matter for Fox Land, correct?
Correct.
Okay, I can put you and Miranda Finley in a private meeting room to see if you can work out an agreement.
My understanding, subject to if she disagrees, that she has worked out an agreement with Foxland Holdings for a conditional consent order for conditional dismissal. The dollar amounts are greatly reduced. There's a total amount of $1,063.82, $900 of which is to be paid by Capital Area Housing Partnership by May 31st. And Ms. Finley shall pay $163.82 by May 31st. I guess I'm asking if that's her understanding. That's my understanding from Foxland Holdings, and Mary Jo Schmidt's here now.
Okay, well, you guys can figure that out in the private meeting room, and if it's her understanding, you can get her consent to sign it, and then we'll go on the record.
Yes, Your Honor.
Okay. Lisa McDonald.
Yes.
Okay, that's Lisa McDonald.
Mhm.
You have an attorney? Ms. McDonald, do you have an attorney?
Unmute. Hello, am I on? Can you hear me?
Yes, you're on. Do you have an attorney representing you at all?
No, I don't, ma'am.
Okay, I'm gonna put you in a private meeting room with the plaintiff's attorney, Mr. Gann, okay?
Thank you.
No problem.
Your Honor, could you also move Ms. Hustle to that room? She's the manager on the site.
No problem.
Thank you so much.
No problem. What happened? Okay, I do see Erica Washington here. Ms. Washington, do you have an attorney representing you?
No, ma'am.
Okay. Have either of you tried to discuss this matter to come to resolution at all? Okay.
Yes, well, over text, yes, we did.
Okay, and there's been no resolution?
No.
Okay, give me just a moment. File has not started his audio. I see Rodney Hodges Jr. I do not see. It's a little early, so we're waiting for the attorney on your matter, Mr. Hodges. I can't hear you, sir. You're muted.
Oh, here we go. Can you hear me?
I can hear you now. Yeah, we're just waiting for the attorney on your matter to appear, okay?
I was gonna say I don't got an attorney.
No, the plaintiff has an attorney though.
Okay. Yeah, I just talked to the landlord the other day, and
Well, let me wait for the other party to get here so we don't have any ex parte communications, okay?
okay.
Thank you. We're on the record in the matter of Chris Keith versus, what did I say that backward?
It's okay.
Keith Chris versus Erica Washington, file number 23-00094 LTE. Mr. Chris is in the courtroom, present in person. You can have a seat at the table there so the mic will pick you up. Erica Washington is present via Zoom. Today was the date and the time that was set for a eviction on a termination of tenancy. And you filed a notice to quit, sir?
Yes.
And I have a notice to quit here. Then I have a complaint. Let's see. And so, Ms. Washington, you believe that you have a lawful defense as to why you should hold over the property or that you should not be evicted?
Can you repeat that, ma'am?
You believe you have a lawful defense or a reason why you should not be evicted from the property?
No, I have no defense.
Okay, so then why didn't you all come to an agreement?
I just need her to move. I offered her a significant reduction in the amount she owed. She hasn't returned the keys yet.
Okay, well, did you file for money judgment in this?
I tried to.
Supplemental damage. I see that you did. It said it was at the time 2,600 rent and arrears.
Yeah.
And what is it that you offered her?
I offered her
To vacate by when?
let me find it.
Do you remember when he told you he needed you to vacate by?
The court date or when he sent the notice to quit?
No, I'm talking about since then. I thought you all were trying to negotiate via text message on how to resolve
Well,
this.
we did. He didn't want to resolve it. When I came up with the money, he said that he didn't want them. He said he wanted the money, but he still wanted me to move.
Okay, well, yeah,
He
you're
didn't.
right, because he filed this as a termination of tenancy versus a non-payment of rent. So he filed it saying he wanted possession of the property, but lawfully doesn't really have to give a reason as to why he wants possession of the property at that time. There is a request for money judgment, and on this, he requested $2,600 for rent that was in arrears. And so lawfully he could get the money and the eviction. But I was wondering if you had a dispute or a reason that you believe should be considered as to why you should be able to hold over the property.
Well, I did. It wasn't really a reason, like nothing happened that I should be evicted. But like he said, he just wanted me to move. It was like nothing I did. I was behind on the rent. And when I came up with the money, he still said, whether you give me the money or not, I still want you out. I still want you to move. So
Okay,
that's what I did.
you didn't believe it would be meaningful for you to pay the money and then negotiate a date for that you can leave, so that maybe he would dismiss the case and you wouldn't get a judgment? You didn't think that would be meaningful?
I tried to pay him some of the money. Even my worker was going to pay a portion of it, and the Sarah was going to also pay an amount. And when I told them that he's still going to kick me out if I pay him the money, they didn't want to release the funds.
I got it. Makes sense.
Okay. Yeah, the original arrangement, I'm sorry.
You can let me know.
Was on January 7th. I agreed to settle. She paid me $1,000 and moved out with the apartment in good condition within 2 weeks of that. So 2 weeks after January 7th.
Okay, so you haven't had a recent negotiation about when she can vacate the property.
No.
And so now we're at the date of the hearing. She does not have a lawful defense or reason that she wants to state to make a claim as to why she should hold over the property. And so that's what I was asking in the beginning, if you all wanted to try to meet typically at these.
When he offered, I'm sorry.
Yes.
I just was going to say, when he offered for me to give him the $1,000 and move in 2 weeks, it was impossible for me to find a place within that amount of time.
I recognize that, but you know what? It would have been more beneficial for the two of you to work together to try to negotiate something, because by law, if I grant an eviction for him today and you haven't given me any reason why I can't, the rent date's 10 days.
I tried to come to some agreement. Like I said he just want me to move. Like he wouldn't give me a reason. He just said, I want you.
He still wants you to move. What I was suggesting was that you all could have worked out a time frame where I'll pay you your money today, but I'll move in. Can you give me 3 weeks? But you all didn't do that.
Correct. He offered 2 weeks, and which I couldn't find anything.
2 weeks from today?
No,
okay,
not
we're here today. What can you offer her today?
I mean, if I can get the apartment returned to me.
You're going to get the apartment returned to you. She didn't give me any lawful reason to hold over the property.
I mean, I don't want to put an eviction on her record. I've tried with her.
I know. But what I'm saying is, are you able to go beyond their standard 10-day rent stay period to give her time to gather her things?
I'd be willing to do that, yes.
Okay, how much time are you willing to give her?
I mean, she said 2 weeks wasn't enough.
Right now, the rent date is the 8th, correct?
Yeah.
Excuse me, Your Honor.
Yes, ma'am.
I'm not there. I'm out of the apartment.
You vacated, you removed all of your things?
Yes, ma'am. I returned his keys.
To him?
No, I left them there in the apartment on the counter.
Look at that. This is good. That was the first thing we should have heard when you got here. So
Yeah,
you returned, she's vacated the property. This is what I'm gonna do. I'm gonna reset this. He's gonna go confirm that the property's been vacated,
Yes, ma'am.
okay? And then if he's satisfied, then he can maybe move in a different direction, because it sounds like he doesn't want to put an eviction on your record. He just wanted the property vacant,
Okay.
okay? So, and you sure you got all your stuff out and you left the key?
Yes, ma'am. I cleaned it out. It was just a couple of items left in the living room, but every bedroom, everything is cleaned out. Through everything
Okay,
is
let me reset this so that he can go and check.
okay.
I mean, and if I may just speak, this has been kind of the issue that's been recurring with this is the lack of communication and.
Got it. May 10th, 1:30. May 10th at 1:30.
Okay.
May 10th and 1:30.
Yes.
Okay, and what would this be, ma'am? This court date?
I'm just resetting the hearing because if you vacated the property, he could potentially dismiss the case, okay?
Yes, ma'am. Okay, I did. I left the keys on the counter for him.
Do you have a way to get inside the property, sir?
Yes.
Okay. Okay, well then we'll see you both May 10th at 1:30.
All right, thank you, Your Honor.
We'll get you a copy of the notice to appear.
Okay.
Thank you, ma'am.
Okay, thank you.
Okay, Mr. Selstrom is back.
Yes, Your Honor.
Did I see Mr. Oppenheimer here? No? I did not. We're on the record. Wait a minute. I don't see. Oh, there she goes. Okay, we're on the record in the matter of Foxland Holdings LLC versus Miranda Finley. File number is 23-00041. Council appearance.
I'm Larry Salstrom on behalf of the landlord. We're back out from the break room. We have had a discussion on what is to be the consent order for conditional dismissal. I'm going to state the economic terms and then ask Ms. Finley if she agrees. It's my understanding, if I get the stated right, she'll agree to my signing her name. The rent that is to be paid by May 31st by Capital Area Housing Partnership is $975. The court calls are to be paid by May 31st are $163.82. And that leaves a total of, that has a total of $1,138.82. What I was not aware of is Ms. Finley has paid $75 toward those court calls. That doesn't alter the court costs, but I want the record to reflect she has paid that, and that is toward the court costs. So the dollar figures are what I just stated. She has already made part payment.
Okay.
And those are the terms as I understand them.
She paid $75 to whom?
To the court, is that who you said, Ms. Finley?
No, I paid it to Foxland Holdings.
Okay, she paid $75. When did you pay that, ma'am?
I want to say it was like last week or the week before.
Okay, how was it that that was applied to court costs and not to her balance of rent?
It was my understanding that she thought she was paying for a late fee that she did not have. So the original rent amounts and who's going to pay it stayed the same, but she gets credit for the money she paid. There's no late fee. It's being waived by the landlord to assist this deal.
Okay. Sounds good. Okay, so the total amount with the rent to retain and a court cost is $1,138.82 to be paid by May 31st, you said?
Yes. Yes, Your Honor.
Okay. Is there any agreement about how incremental payments, or is she just gonna pay it by then?
Can I say something? Hunter?
Give me
Go
a
ahead.
moment to get this cleared with the attorney. Mr. Salstrom, is she gonna make a certain amount of payments, or is just long as she gets it paid by then?
Paid by then, but it's my understanding that the $975 is going to be paid by the Capital Area Housing Partnership, but it's to be paid by May 31st.
Okay, ma'am, you wanted to say something? You're muted.
I just was trying to clarify that Capital Area Housing Partnership was paying the $975, and then the remaining balance is like 80 something dollars that I owe.
That's correct.
That sounds accurate.
That's a net
Okay.
dollar amount off the payment she's made.
Correct. That sounds accurate. Okay, so Ms. Finley, you are willing to enter into this agreement for conditional dismissal at this time?
Yes, ma'am.
And have you given Mr. Salstrom a permission to sign your name to this conditional dismissal?
Yes.
Okay, you understand that you have the right to be represented by counsel in this matter?
Yes.
You're gonna waive your right to be represented by an attorney?
Yes.
And you also have the right to have a hearing in this matter, or you could have demanded a jury trial. Are you waiving your rights to trial in this matter?
Yes.
Anybody promising you anything or threatening you to get you to waive those rights?
No.
Okay, you understand partial payment will not satisfy the agreement. You have to make sure it's paid in full by the 31st of May, correct?
Yes, ma'am.
Okay, you have 3 business days from today. If you leave here and determine that you misunderstood any of the rights that you are waiving, you can request to have this matter set for a hearing, okay?
Okay.
Mr. Salstrom, you can sign on her behalf and submit it to Judge Simmons Courtroom at lansingmi.gov.
That will be done, Your Honor.
Thank you.
Thank you,
Any
Your Honor.
additional matters for the record, sir?
No, Your Honor.
Okay,
No,
you're
we're
all set,
done.
on this matter. Thank you, Ms. Finley.
Thank you.
You're welcome. I don't know. Okay, Lisa McDonald is here. Mr. Gann?
Yes, Your Honor.
Matt? Okay, we're on the record in the matter of the Porter Limited versus Lisa McDonald, file number 23-00034, counsel appearance.
Yes, ma'am. Steve Gann, P7829, appearing plaintiff on this matter. I have had a chance to meet with the defendant in the breakout room. We do have a resolution.
Okay, please state the resolution on the record.
Yes, ma'am. At this time, there is currently due and owing for possession $1,089 plus $211.98 in court fees for a total of $1,300.98. There's a money judgment that's paid for, and that's been reduced prorated through today of $1,064 plus a $211.98 for $1,275.98. She understands that she's got 10 days to get it paid or moved. She's working through agencies. Because the 10-day falls during the weekend, I have put on the judgment May 8th, 2023. And I'm prepared to submit this judgment to the court for approval. I have explained 4.201I to the resident with regards to her right to an attorney, a right to trial before this honorable court, as well as the right to come back to the court in 3 days if she indicates that she did not understand what the terms were today. But I also explained to her that you would also cover them with her to make sure she understood. So it may be a difficult burden to her to prove that.
Thank you. Ms. McDonald, is what Mr. Gann stating your understanding of how you're proceeding today?
Yes, it is.
Okay, so you want to enter into a consent judgment. You're agreeing to pay the amount of $1,398.
Yes, ma'am.
I'm sorry, is it $1,300.98? Is that accurate, Mr. Gann?
That is correct, Jeremy. I actually just scanned the judgment to your courtroom 2 minutes ago.
Okay, very good. And you're agreeing to make that payment on or before May 8th?
I am.
Okay. It's not been received yet, but nonetheless, you understand that you had the right to have a hearing or a trial in this matter, Ms. McDonald?
Yes, I do.
You're willing to waive your right to that trial in order to enter to consent judgment?
I am.
And you also have the right in this matter to be represented by counsel. You've appeared without an attorney. You're waiving your right today to be
Yes, I
represented by
am.
counsel?
Yes.
Okay, anybody threaten you to waive your rights today?
No,
Has there been any promises made to you in exchange for waiving your rights?
no,
Okay, and have you given Mr. Again permission to sign your name to this agreement?
I have.
You have 3 business days from today to return to the court. If you leave here and determine you misunderstood the rights that you're waiving, you can request to have the judgment set aside. You'd have to articulate to the court how it was you misunderstood your rights, okay?
Okay,
Okay, do you have any questions at this time, ma'am?
I do not.
Okay, Mr. Gann, any additional matters for the record?
No, ma'am.
Okay, you're all set, Ms. McDonald, thank you.
Thank you, Judge.
Thanks so much. You have a great day. Good luck, Ms. McDonald.
Same to you. Let's see. Someone on the iPhone. What's your name, ma'am? Yes, you, ma'am.
Uh,
I'm sorry?
Justine Dar.
Oh. Your attorney here for the Dean Heritage?
No.
That's me, Curtis Barnes, Your Honor.
Okay, very good. And so Justine and then Mr. Shashagwai, did I say that right? Shashagwai?
Shagway.
Shashagwai. Do you have an attorney?
I do not know.
Okay, Ms. Dar, do you have an attorney?
No, I do not.
Okay, we're gonna put you in a private meeting room with the plaintiff's attorney so that you can see if you can work a resolution out.
Okay.
Ms. McDonald is free to go. Where's Mr. Arkaneki? Okay. Mr. Hodges is here. I don't know where the attorney is, Mr. Hodges. Pay your rent. If we can unmute.
Back on mute. Yeah. No.
Did you pay?
No, I talked to him Monday.
Okay. Uh-huh.
I gave him 1,000, and I'm giving him 1,000 on Friday, this Friday coming up. And then I'm working with the I think St. Vincent de Paul for to help pay the rent.
Okay, well, you continue to do that. I don't know why the attorney has not appeared, but neither has the landlord. I'm not sure why that was set for 2:45. But so I'm going to go ahead and dismiss the case for lack of progress. But oh, wait a minute, they might be running down the hallway.
What's that? Yes, sir.
Maybe not. What's going on up here?
I'm back on mute.
Yeah, I muted because I thought he was pointing to tell me that Mr. Arkaneki was out there, but I'm gonna double check.
Still on. Let me just.
Just paid some money. Mr. Hodges, Mr. Ockeneke was tied up. He is here. He said you said you made a payment last week, sir?
No, that was I want to say about 2 weeks ago. So I'm making a payment on Friday. So that's like I get paid every 2 weeks. So every 2 weeks I bring some money. So I only get paid twice a month. So the first check is normally the check that I give them for rent. So I've been giving them 1,000. Yep, I've been giving them 1,000.
Mr. Hodges, my record showed that you paid I had $1,000 payment, and the total that was still owed that I had was $3,000 plus 210 in court costs.
Yeah,
That's $3,210. If you wanted to make that payment arrangement where you made $1,000 payments every 2 weeks, is that what you said? Or what did you say, every month?
I talked to Kyle. So I don't know if Kyle talked to you. I talked to Kyle on Monday. So I don't know have you talked to him since then. I talked to him Monday.
So I have $3,000 in rent due and $210 in court costs due. How did you and Kyle agree to pay that?
Yeah, I told him that I was gonna give him $1,000 every 2 weeks, but I told him the St. Vincent de Paul, right now, they were waiting for my decision to come back. And they also wanted me to get the amount down under 3. And I told them once I gave you the $1,000, which is here in 2 days, when I get paid, I was gonna get the paperwork for them because I already have everything, the pay stubs, all the information they need. They just were waiting on the decision. I got the decision back, and then now they just want me to get the balance down. So I had to wait till I got paid, give you the 1,000 to have you guys send me a copy showing that the balance is under 3,000, and then they're gonna submit my information to help.
Mr. Hodges, if I do a conditional dismissal that says there's $3,210 owed, and that you'll be making $1,000 payments every 2 weeks until the balance is paid in full, and then you can do whatever you want with this order and take it to St. Vincent's and get the money if you want. But is that agreement? You'll make $1,000 payments every 2 weeks?
Yeah, I can do
When's
that.
the next one gonna be made?
Yeah,
When's the next one gonna be made?
The 28th of this month. So like a couple days.
Okay, so what this is gonna say, is that you have $3,000 due in rent, $210 due in court costs, $3,210 total. That's through the period ending April 30th.
Yeah, I was listening. Would you stop at what? I don't know if it's like.
And
Mine's,
am I okay? Am I okay to sign what I just said on your behalf and give it to the judge? The agreement we just made?
Yeah, the $1,000 every 2 weeks.
Yep.
Yeah.
Okay, I'm gonna sign this on your behalf and give this to the judge to enter. And if the court enters it, that'll be the agreement. And if you have any problems, just get with Kyle.
Yeah,
Okay.
Yep, no problem. Yeah, I told him I'll drop it off.
Sounds good. You should.
All right.
Okay.
Wait a minute, sir. Okay, I have the conditional dismissal here that reflects what was just stated here before the court, and you've given Mr. Ockeneke permission to sign on your behalf. You're gonna pay the total amount of $3,000 in past due rent plus court costs, $210 for a total of $3,210 on or before April 30th, 2023. You're gonna make payments of $1,000 every 2 weeks until paid in full starting April 28th. That's correct, sir?
Yes.
You understand partial payment won't satisfy this agreement?
Yes.
Okay, and is anybody threatening you to waive your rights to be represented by counsel in order to move forward in this direction?
No.
Any promises being made to you to get you to waive your right to trial or representation?
No.
Okay, you have 3 business days to return to the court. If you leave here and decide that you misunderstood the rights that you just waived, you can request to have that agreement set aside and we'll set it for a hearing, okay?
Yes.
Okay, you're all set for today. We'll send you a copy of the conditional dismissal.
Thank you.
You're welcome. Have a good one.
You too.
The record in the matter of the Dean Heritage versus Kyle Shashagway and Justine Dar, file number 23-00078 LT, council appearance.
Curtis Barnes for the dean, Your Honor.
Okay, and Mr. Shashagway and Ms. Dar are present via Zoom without counsel. Mr. Dean, Mr. Baris, did you all come to an agreement on behalf of this eviction?
We're in close, but we have a couple of things. And my manager, from the dean, just was able to get on the Zoom. I came in here to see if you could throw us back in a breakout room because she would help in possibly resolving one of the disputes that we are having.
Okay, I think everybody left probably when you left. All 3 of you all can go back to room 1. You just look on your screen and it'll say breakout room or return to breakout room.
Okay. Okay, I see it. Yeah, join breakout room.
Yep.
Oh.
How's it going? Not too bad.
Call from that detective sergeant. Trooper that sent you the warrant, his wife is going to be up late, so he wanted to know if you could send the warrant to.
This officer?
Yeah,
Which one? Who's in the room? This one?
the warrant.
That's him.
But
the windows.
Okay, Mr. Berenz, are we ready to proceed?
Yes, Your Honor.
Okay, we're on the record of the matter of the deed heritage. Counsel, how did you want to proceed?
Well, Your Honor, we had a chance to talk, and at this time, we are going to be dismissing the case against Kyle only, and entering a judgment as to Miss Dar. The judgment would be for a total of $5,136.23. That's inclusive of rent, late fees, utilities, and court costs. And that's the possession judgment. And then there's also a prorated money judgment. The total is $5,012.15 and it's been prorated to today's date.
Something's going on with your connection. I don't know if something by the window, but it kind of muffled you. So we don't really know what the numbers are that you said. Could you repeat those numbers? And so this is the consent judgment against Ms. Dar only?
Correct.
Okay, and what was the possession amount?
The possession amount in total was $5,136.23.
Okay. And there was a money judgment, you said?
Yes, and the prorated money judgment amount is $5,012.15.
Okay, so the matter against Mr. Shashaway is dismissed. And then Ms. Dar, can you unmute, please?
Yes.
Okay, Ms. Dar, you're entering into a consent judgment today?
Yep.
Okay, so your understanding is that you're going to waive your rights to have representation by counsel, and you're going to waive your rights to have a trial in this matter in order to grant judgment in favor of the plaintiff in the amount of $5,136.23 to retain the property. And you're going to make that payment on or before May 8th.
Is there any way I can get some kind of payment plan or something to help me kind of get the money paid off?
We had talked about this, Your Honor, and at this point, the landlord isn't willing to give more than the statutory 10 days. So
no, if the landlord doesn't want to accept the payment plan, then that's up to them. We can't order a payment plan, okay, ma'am?
Okay.
Okay, and so there is a money judgment to issue in the amount of $5,012.15. And so you're entering into a consent judgment as to that as well, ma'am?
Yes.
Anybody threatening you to get you to waive your rights to have representation by counsel or your rights to have a hearing in this matter?
Yes.
Who's threatening you?
Or no, I'm sorry. I misheard.
Okay, no problem. Any promises being made to you in exchange for you waiving your rights today?
No.
Okay, you have 3 business days from today to return to the court. If you leave here and you determine that you misunderstood the rights that you're waiving, you can request to have the judgment set aside and we'll set up for a hearing. You'll have to articulate to the court how you misunderstood your rights, okay?
Okay, sounds good. Thank you.
No problem. Lastly, did you give Mr. Behrens permission to sign the consent judgment on your behalf?
Yes, I give.
Okay, do you have any questions for the court, ma'am?
Not right now. No thing, or no.
Any additional matters for the record, counsel?
I have submitted that judgment to the court to the email provided. Does the court need a written dismissal, or is the dismissal as to Kyle on the record enough?
Dismissal as to him on the record is fine.
Thank you, Your Honor.
Thank you. You're all set. Who's on the phone number ending in 1615?
Hello,
Oh, yes, who are you?
Clifford Lofton.
Okay, Mr. Lofton, you need to appear with video.
With a video?
That's correct, sir.
No, I told him I didn't have a computer.
Oh, then you were supposed to appear in person.
They told me I either could do it over the phone, and they gave me this number, and they told me, because I told them I was sick. Yeah, didn't they tell you that? Didn't somebody explain that to you?
Excuse me?
Didn't somebody tell you that? I was sick today.
You can appear via Zoom. They didn't say you can appear via telephone.
Well, they gave me this number and they told me to call like this.
I don't know who gave you that number, sir. But I gave you a notice. I gave you a notice to appear the last time you were here, and it also you had Zoom instructions. And so you need to log in. You need to download the Zoom app on your device and log in so that we can conduct a hearing. Okay.
With my telephone?
That's correct, sir.
Okay, so, because first was that you that I talked to earlier?
You didn't talk to me earlier. This is Judge Simmons.
Oh, yeah. They told me that they gave me this number, and then they told me to.
I recognize that there may have been some miscommunication. I don't know who you spoke to. It was not my court staff. You probably spoke to the clerk's office, but I have a very strict policy. I don't conduct hearings via telephone. I don't know who I'm talking to, sir. I don't know. You could be sitting in the hallway drinking alcohol for all I know. I need to be able to conduct the hearing and to look at who I'm talking to.
Okay, because I told them that I was sick. I have diarrhea.
I don't want to know. I don't want to know what you're sick with, sir. All I want you to do is download the Zoom ID so that you can conduct this hearing. And you were late for court last time, remember?
Right.
Right. So we reset this. So you need to be compliant. So you need to go on ahead and get that app downloaded so that you can log in and we can conduct the hearing, okay?
Okay, download it on the telephone?
Yeah, you got to download Zoom on your phone. It's an app.
Okay. Ooh, I don't even know how to do that. How do you do it?
Sir, I can't navigate your IT for you. I don't even know what kind of phone you have.
I got this is a smartphone.
Your Honor, this is Attorney Craig Dates. I'd be happy to go in a breakout room and try to walk them through it. And
thank you so much.
You're welcome.
Okay. He's not, because he's on the phone. Let me see. It's gonna automatically put him in there. Let me put him in room 1. Who's on the Samsung SMA23U? Okay. Can you unmute, please, and tell me your name?
Jamie Bonner.
Okay, do you have an attorney?
I don't.
Okay, very good. And then I see Kendra Bishop. Do you have an attorney, Ms. Bishop?
I do not.
Mr. Whitty, are you available?
I am, Your Honor, and I'd be happy to meet in a breakout room with my property manager.
Okay. Let's see, room 2 with Kendra Bishop, and then we'll do Ms. Bonner next, and you want your property manager in there as well.
Yes, thank you.
Anybody present on behalf of Toyin Adeli? Okay, that one is dismissed. And then Ms. Hart is here on the matter of Stonecrest versus Alicia Thompson.
Yes, Your Honor, that's correct. I'm here.
No one has appeared on behalf of Alicia Thompson, so you can submit default.
Thank you, Your Honor.
Thank you.
And I believe that concludes it for us today. Have a great rest of your day.
Thank you, same to you.
Thank you.
What do I have? Whose file is this? Oh, Mr. Lockley.
Your Honor.
Hello?
Your Honor, I gave Mr. Lofton to go down to the property office and see if they can get him on Zoom by 4. If not, I'd be so gracious to allow an adjournment so I don't have to hear about his sickness and give him a new
Oh,
date.
wonderful, wonderful. Thank you so much.
You're welcome.
Mr. Woody, are you ready to move forward with Ms. Bishop?
Yes, Your Honor.
Okay, we're on the record in the matter of LG Park Place LLC versus Kendra Bishop, file number 23-00137 LT, council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, LG Park Place LLC.
Okay, Ms. Bishop is present via Zoom. Mr. Woody, how did you guys decide to resolve this matter?
Your Honor, we had a conversation in the breakout room. I'm pleased to report the parties have agreed to enter into a consent judgment in this case. If I may put those terms on the record.
Please do.
Thank you, Your Honor. At this time, there's currently rent to retain possession due in the amount of $5,990. Court costs are due in the amount of $240.63 for a total possession judgment amount of $6,230.63. Ms. Bishop would have to either move or pay that amount by May 8th. We also asked for a money judgment in this case, which is why we're not doing a conditional dismissal today. Rent prorated through today's date is $5,874. Court costs are $240.63 for a total money judgment claim of $6,114.63. I explained to Ms. Bishop that partial payment would not stay issuance of an order of eviction in the case, and we did go over her rights under MCR 4.201I, and she indicated that I would have permission to sign the consent judgment on her behalf, and I'd like to confirm that on the record if I could.
Okay, very good. Ms. Bishop, is what Mr. Woody just stated on the record your understanding of how you're going to proceed today?
Yes.
Okay, so you are entering into a consent judgment and you are agreeing to pay the amount to retain possession of the property $5,990 plus court costs of $240.63 for a total of $6,230.63. And you're going to pay that on or before May 8th, or a writ will issue by that date, correct?
Correct.
Okay, and so you also have a money judgment in the amount of $5,874 plus $240.63 in court costs for a total money judgment of $6,114.63. That's correct to you, ma'am?
Correct.
Okay, you do recognize that you have to give up the rights to be represented by counsel today in order to enter into this agreement?
Yes.
And you want to give that right up?
Yes.
You have to give up your right to have a trial or a hearing in this matter. You want to waive that right today?
Yes.
Anybody threatening you to get you to waive your rights?
No.
Any promises being made to you in exchange for you waiving your rights?
No.
Are you giving Mr. Whitty permission to sign the consent judgment on your behalf?
Yes.
And you recognize that partial payment on this judgment will not satisfy the judgment. You have to pay that amount in full or vacate by that date. You recognize that?
Correct.
Okay, you have 3 business days from today's date. If you leave here today and determine that you misunderstood any of the rights that you're waiving in order to enter into this consent judgment, you can return to the court and file a motion to set aside the judgment, and we'll set it for a hearing. You'll articulate to the court how it was that you misunderstood your rights, okay?
Okay.
Do you have any questions at this time, ma'am?
No.
Any additional matters for the record today, Mr. Whitty?
Nothing further, Your Honor. Thank you.
Thank you. You're all set, Ms. Bishop. Mr. Whitty, I just added Ms. Bonner to room 2.
Thank you.
No problem.
Kathleen from Sycamore Townhomes.
Yes. Yes, I'm still waiting on Mr. Laughlin to come up here.
Okay, I just want to make sure you heard me, that he's on his way, so
Yep, I'm waiting.
thank you.
Yep.
Okay, Mr. Woody, are you ready on Ms. Bonner? On the record in the matter of LG Park Place LLC versus Jamie Bonner, file number 23-00138 LT. Council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, LG Park.
And since Ms. Bonner is present via Zoom, I'm going to go ahead and mute her because there's a lot of feedback going on in wherever she is. Today's the date and the time that
We lost you, Judge.
we reached our 8-hour cap and they booted us out.
Oops. Working along today.
Okay. Now back on the record, and today was the date set for a hearing. Mr. Woody, you came to an agreement?
We did. I'd be happy to put those terms on the record if I may.
You may.
Thank you, Your Honor. Your Honor, the parties agree that at this time there's rent to retain. This is going to be a consent judgment, Your Honor. Parties agree that rent to retain possession is due in the amount of $10,563. Court costs in this matter are $242.99 for a total possession amount of $10,805.99. Ms. Bonner would either have to pay that amount or move by on or before May 8th, 2023, or we would be able to seek a writ of restitution in this matter. The parties, she understands that partial payment would not stop issuance of an order of eviction in this case. We also requested a money judgment in this case, which is why we didn't seek a conditional dismissal here. Prorated rent through today's date is $10,440.33. Court costs are the same $242.99 for a total of $10,683.32. I reviewed the terms with Ms. Bonner and talked to her about her rights under MCR 4.201I. At the conclusion of that discussion, she authorized me to sign the consent judgment on her behalf, which I'd also like to confirm on the record.
Thank you. Can you give me the prorated money judgment amount again?
The damages are $10,440.33. Costs are $242.99. total of 10,683.32.
Okay, Ms. Bonner, you understand what was stated on the record here today?
Yes.
Okay, and you want to enter a consent judgment agreeing to those amounts?
Yeah.
Okay, so you understand that you had to have, or you have the right to be represented by counsel in this matter, ma'am?
Yep.
You're willing to waive your right to be represented by an attorney in order to enter a consent judgment today?
Yes.
You also have the right to have a jury trial, or you could have had a hearing today. Are you willing to give up your right to trial in order to enter into consent judgment today?
Yes.
Has there been any threats made to you in order to get you to waive your right?
No.
Any promises being made to you to want to waive your right?
No.
Okay, so you're agreeing to pay the amount to retain total amount of $10,805.99. That includes $10,563 for rent and retain plus $242.99. Ma'am, you understand that?
Yes.
And you're going to make that payment on or before May 8th?
Yes.
You understand partial payment will not satisfy this judgment?
Yes.
Okay, and there's also money judgment to issue in the amount of total $10,683.32. You understand that?
Yes.
That includes your prorated rent amount plus court costs.
Yes.
You have 3 business days from today's date to return to the court. If you leave here and determine you misunderstood the rights that you're waiving to enter into a consent judgment, you can request to have the judgment set aside. You would have to articulate to the court how it was that you misunderstood your rights. You understand that?
I do.
Lastly, are you giving Mr. Woody permission to sign the judgment on your behalf?
Yes, I am.
Okay, do you have any questions for the court?
Nope.
Any additional matters for the record, counsel?
Nothing further for plaintiff, Your Honor.
Thank you. You're all set, ma'am.
All right, thank you.
Thank you.
Thank you, Your Honor. Have a good day.
Same to you. Okay, Mr. That's my understanding is that our friend, Mr. Lofton, has contacted the court clerk again and said he was going to appear. He's just going to come up here, but I don't know where he is.
Just reset it for a new one and we'll just see what happens next time.
Correct. Let's put him early. You gotta add a slot. You gotta make sure he can get here.
It's already like 5, about 1:30.
6. What's going on at 2? Less than 2. May 10th at 2. May 10th at 2 p.m.
Thank you, Your Honor.
Thank you. Put him in person so he can make sure he gets here. Any additional matters today, sir?
That's all I had, Your Honor. Thank you.
Thank you. Have a good one.
And thank you, Kathleen, for